So, ladies and gentlemen, just I have pointed out the classification of divorce. Basically, this classification is of a academic nature, to drive the points home clearly to the audience or the students, how in different way or how by different modes union of marriage or nikah can be put to end either by the husband or by the wife or by both with their mutual consent or on the petition moved by wife on the grounds as laid down under section 2 subclause 1 to 9 of the Dissolution of Muslim Marriage Act 1939, which is also known as first or judicial divorce. That is also recognized as a mode for the dissolution of Muslim marriage by the law itself. So now, first of all, I would like to discuss divorce by husband. In the beginning of my talk, I have spoken that when union of marriage is repudiated by the act of the husband, that is by means of pronouncing or uttering certain words, this is known as talaq. Talaq, here talaq is an Arabic word, root word is Arabic, which means undoing of or release from a knot. It is used, that is, the talaq is used by the Muslim jurists to denote the release of women from the contract of marriage or from the marital tie. So, when the marriage is repudiated by utterance or by pronouncements or by writing words of talaq by the husband to release the wife from the contract of the marriage, such a repudiation of marriage proceeding from the husband is called as talaq, and in effect it terminate the union of marriage. Ladies and gentlemen, divorce by husband, or that is talaq, is further classified into two classes. One of them is known as Talaq-ul-Sunnat and other is called as Talaq-ul-Biddat, meaning thereby that power of repudiating marriage by the husband, which is known as talaq, may broadly classified into two subclasses or into two subcategories. One is known as Talaq-ul-Sunnat and other is called as Talaq-ul-Biddat. Now the point is, what is Talaq-ul-Sunnat? Ladies and gentlemen, when the contract of the marriage is repudiated by the husband according to the rules and procedure are laid down by the Sharia law, or that is by the Holy Quran, saying of the Holy Prophet, that is called as Talaq-ul-Sunnat. it is that formula or form of the divorce which is pronounced in the manner and in the time frame prescribed by the Muslim law. Here, it should be clarified to the audience that expression Talaq-ul-Sunnat does not mean that it is an act of piety or that it shall entitle one to reward of a virtuous act. Talaq-ul-Sunnat here only means that a formula of the divorce pronounced by that procedure which commands the approval of the Holy Book, Holy Prophet and his companions, and which is least controversial in practice. Therefore, it is called as Talaq-ul-Sunnat. Sunnat means the way shown by the Holy Prophet, or the way of doing something as pointed out or practiced or permitted by the Holy Prophet, by his doing, by his saying, or by his conduct. Therefore, here Talaq-ul-Sunnat means that formula of the divorce which commands approval of the Sharia, that is fundamental sources of Muslim law, and which is least controversial in practice. And in later stage I will discuss when its kinds. I will also try to establish that formula of the Talaq-ul-Sunnat is just, fair, reasonable, and is in consonance with the principle of natural justice, which is cardinal principle of justice in modern time, even in under all the modern legal documents known as constitution or the grand norm. Talaq-ul-Sunnat is further divided into two following classes. One of them is known as Talaq-ul-Ahsan and other is known as Talaq-ul-Hasan. Valued audience, Talaq-ul-Ahsan basically is the one of the form of Talaq-ul-Sunnat. It is first and foremost kind of Talaq-ul-Sunnat. It is also known as most approved form of divorce. It is also called as best formula of the divorce. It is a best form of the divorce. In this form of the talaq, that is in Talaq-ul-Sunnat, one single revocable divorce is pronounced by the husband upon his wife during the period of tuhar, in which the wife is free from menstruation and in which she has not been consummated. In Talaq-ul-Hasan, after pronouncement of single divorce, wife is allowed to undergo a period of Iddah in the same matrimonial home where she was putting up immediately before the pronouncement of the divorce, and she is required to observe the Iddah period for 3 months, or till the delivery of a child, in case uh, she was pregnant at the time of pronouncement of single divorce upon her. Uh, so Talaq-ul-Ahsan is exactly based on the saying of the Holy Prophet, uh, uh, that is Ahsan form of the divorce is husband is in Talaq-ul-Ahsan, the husband is required to pronounce it's basically Talaq-ul-Ahsan is what I wanted to convey, that formula of the Talaq-ul-Ahsan is said to be the best form of the divorce, most approved form of the divorce. It doesn't mean that Sharia has encouraged its follower to pronounce the divorce frequently by resorting to this, because it is most approved, it is the best form of the divorce. It is called as the best form of the divorce because in this form of the divorce there is less inconvenience to the parties and more opportunity of reconciliation, reunion, and of starting a fresh life by uniting with each other. Therefore, this formula of the divorce is called as best form of the divorce. And this formula of the divorce basically is based on the verses of the Holy Quran as well as on the saying of the Holy Prophet, because the Holy Quran Holy Quran has provided a procedure for pronouncing the divorce, and the procedure which is indicated in the Holy Quran for pronouncing the divorce upon his wife in case they are not pulling on well and effort of reconciliation has failed, divorce has become inevitable, then how the parties to separate from each other, how they should separate from each other by dissolving the marriage, it is clearly indicated in chapter 2, verse 228, 29, 229. Read with some other relevant verses enshrined in chapter Surah Talaq, verse number 1, verse number 2, and there are some other relevant verses. Together they provide a formula as to how in an inevitable circumstance union of marriage should be repudiated or should be terminated by the husband by pronouncing divorce upon his wife. Therefore, author of a celebrated book on hadith, that is Muwatta, Imam Malik, written by Imam Malik. What is Talaq-ul-Ahsan? Talaq-ul-Ahsan is Talaq-ul-Ahsan is that form of the divorce or talaq which the husband pronounces to his wife in the state of purity without having sexual intercourse with her, in that state which she attains after menstruation. Therefore, to regard a pronouncement of divorce as Talaq-ul-Hasan, it must be preceded by the following conditions. Number 1, that husband must pronounce the divorce once in a single sentence. He must pronounce the divorce when the wife is in a state of purity, that is called as tuhar. he must abstain after pronouncing the divorce, single divorce. He must, that is, he here means husband. Husband must abstain from cohabitation uh, for the whole period of the iddah, that is 3 months. Uh, this formula of the divorce is called as the best form of the divorce because uh, during the period of iddat, which is 3 months, in case there is a pronouncement of divorce and wife is not pregnant, then the period of the iddat will be 3 months. And during this period of the iddat, Muslim law requires that wife upon whom the divorce has been pronounced should stay in the same matrimonial home along with the husband in the same way as she was living immediately before the divorce or before the pronouncement of the divorce. And during this period, she should be maintained and treated as she was being maintained and treated immediately before the pronouncement of the divorce by the husband. And this is required because this may afford the opportunity to the parties who have separated for each other by pronouncing the divorce for reunion or for reuniting. This is a cooling period. This is called as a period of iddat provides the parties time of cooling off, an opportunity to rethink, and if after giving a second thought or rethinking over the decision which has been taken by them either with their mutual consent or by the husband has pronounced or husband has himself pronounced the divorce with reasons, without reasons. So this period of the iddat is prescribed and it is prescribed for a period of the 3 months. There is a philosophy and there is a social philosophy, and the philosophy is that if after pronouncement of divorce both the parties are still living together in the same house, there is a possibility that they will realize the what they will realize the importance of their unity. They can also realize what they are going to lose and what they are going to lose again in terms of their own life, in terms of their children, in terms of their family, and in terms of the society in around them. And this can prompt them to realize that their decision has been, they have taken the decision in haste, which may not be good for their future life, for the life of their children, as well as for the life of their family member, and therefore they can decide to revert back, and during the period of the iddat they can revert back with each other just by cohabiting with each other. And therefore, since in this formula of the divorce there is a ample opportunity of reverting back to each other, reuniting with each other by cancelling their divorce. Therefore, this formula of the divorce is called as the best formula of the divorce, most approved form of the divorce. And this is also called as the approved form of best formula because the best opportunity is available to both the parties again to revive their union by cohabiting with each other. However, if reconciliation could not be possible during the period of iddat and husband remains husband does not or wife does not reconcile or they do not reconcile with each other, their point of difference subsist and continue, then on the lapse of the term of the 3 months, that is iddat period, the separation takes effect as an irrevocable divorce. So means If husband has pronounced a single divorce in a period of purity, followed by a period of iddat by the wife, and during the iddat if reconciliation could not be possible, they could not revert back to each other, one divorce on the expiry of the period of iddat will take effect, and this will be an irrevocable divorce. After the expiry of the period of the iddat, they cannot revert back to each other if they wish. However, even if one irrevocable divorce has taken place in formula of Ahsan form, and resolution of marriage has finally taken place, they have finally separated from each other, marriage has come to an end finally, even then in this form of the divorce still there is a scope of reunion. What is that very scope? That even after the expiry of the period of the 3 months, they can revert back to each other just by contracting a fresh marriage. No intervening marriage is required, which is known as halala. In Ahsan formula of the divorce, what is the best and most convenient thing to the parties, that even if they could not resolve their dispute which led to the dissolution of the marriage or divorce by the husband, even during this long period which is 3 months, and on the expiry of the 3 months my marriage has finally dissolved, it has resolved irrevocably, parties have become a stranger for each other, all the bonds created by the marriage has come to an end, they have become stranger for each other, they might have taken their own way for the future life. Even thereafter, at any point of the time, they think that they have committed a blunder, they have committed a mistake, and their mistake may cost dearer to them, and they again are wishing to come back to each other in their own interest, in the interest of their children, in the interest of their family members. Still Muslim law provides the scope for them. Still there is a scope for them to reunite with each other, and they can reunite with each other just by contracting a fresh nikah or fresh marriage. Offer by one, acceptance by other, and if this offer and acceptance with their mutual free consent in the presence and hearing of the two competent witnesses takes place, they will reunite with each other, and they can, and thereafter they can start their life, marital life, matrimonial life afresh as it was started after the first marriage. After the first marriage. Therefore, this formula of the divorce is known as the best formula of divorce. The other formula of the Talaq-ul-Sunnat or other part of the Talaq-ul-Sunnat is known as Talaq-ul-Hasan. I have already pointed out that Talaq-ul-Sunnat is broadly classified into two. One is known as Talaq-ul-Ahsan and other is known as Talaq-ul-Hasan. I have already pointed out what is Talaq-ul-Ahsan. And Talaq-ul-Ahsan has also been approved. Ahsan formula of the divorce has also been endorsed and approved by the Supreme Court in successive judgments. Shamim Ara versus State of UP, wherein the Supreme Court has tried to explain what is the way of pronouncing the divorce as approved by the Muslim law, that is fundamental sources of the Muslim law. And according to the observation of the Supreme Court in Shamim Ara versus State of UP 2000, every divorce must be preceded by a reconciliation. If reconciliation at the end of the parties fails, then divorce must follow. Only then divorce should follow. But how the divorce will follow, How the divorce will be pronounced? It has been pointed out that it should be pronounced in Ahsan form, that is one single divorce in a single period, in a period of purity, when the wife is free from menstruation, and thereafter wife is allowed to observe the Iddah period in the same way, style, in the same place where she was immediately before the divorce. During this period, efforts should be made by the parties to reconcile their point of differences leading to the divorce or pronouncement of talaq by the husband. If reconciliation could be possible, they can cancel the divorce and revert back to each other and restart their matrimonial life as it was before the marriage, before the pronouncement of the divorce. This has been uh, laid down by the Supreme Court in the course of the observation while explaining the correct formula of the divorce as sanctioned by the Muslim law or authorities on Muslim law. Also, the Supreme Court, while dealing with the triple divorce, has acknowledged that the correct formula of the divorce is that which is known as Talaq-ul-Ahsan. Shaira Banu versus State of Jharkhand, which ultimately led to the passing of Muslim Women Protection on Marriage Act 2019. In that very case also, the Supreme Court has accepted that this is only the correct formula of divorce, that is Talaq-ul-Ahsan. So now, what is Talaq-ul-Hasan? Talaq-ul-Hasan is second approved form of the divorce by the husband who has consummated the marriage, pronounces one divorce during each 3 successive periods in which the wife is free from menstruation and has not been cohabited with. In Arabic word, the Hasan means good or proper. In this form, the husband pronounces the form 3 divorces, one in one period of purity, second in the second period of the purity, and third in third period of the purity. On the third pronouncement, the talaq becomes irrevocable, and third divorce pronouncement made by the husband renders the marriage absolutely irrevocable. This is called as the Hasan formula of the divorce, because in this formula of the divorce, as compared to the first one, there is limited opportunity of reconciliation, rethinking, and cooling off. Because in this formula, as and when there is a dispute between the parties and conciliation, mediation has failed to bring them back on the good terms, and as a Hasan formula of the divorce is resorted to effect the divorce, husband will pronounce one divorce when in the state of purity, that is when wife is free from menstruation. She will wait for the next month, and in the next month, when after having menstruation she has become free, that period again will be called as period of purity, state of tuhar, and husband will again pronounce the second divorce. After pronouncement of the second divorce and first divorce, still the husband has opportunity to revert back to his wife and resume the marital relation. Even after first pronouncement in first period of the purity, after the pronouncement of the second divorce in second period of the purity, and until the reaching of the third period of the purity and pronouncement of the third divorce. In between, the parties have the chance of reconciliation, reverting back to each other, opportunity of being heard to each other will be available, and in this way they can come back to each other and reunite with each other. But in third period of the purity, again if the husband pronounces the third divorce third time, so as soon as the third divorce in third period of the purity is pronounced by the husband deliberately, intentionally to effect the divorce, this third divorce will not only render the marriage irrevocably dissolved, but at the same time parties will also lose the opportunity of reconciliation, reconciliation and reunion, because according to the Holy Quran, divorce is permissible only twice. Means two divorces are permissible. Up to two divorce, husband and wife have opportunity, ample opportunity, abundant opportunity of coming back to each other. But once third divorce is pronounced, marriage will come to end finally, and thereafter even if they want to reunite, they cannot unless there is a intervening marriage that is known as halala, which is again a very controversial aspect of the Muslim law, pending for decision before the Supreme Court. This Hasan formula of the divorce and talaq and this halala, nikah halala, both are pending for decision before, and both are under challenge. Petitioner has made the point that only Talaq-ul-Ahsan is indicated in the Holy Quran. Talaq-ul-Hasan, and there is no mention of this halala. They are the customary part of the law, and therefore this should go from the practice. It should also be declared as illegal and void, as the triple divorce has been declared illegal and void by the Supreme Court. So Talaq-ul-Ahsan is called as good or less approved because Talaq-ul-Hasan is not unanimously approved. On the basis of the interpretation of the verse 2, at-talaqu marratani fa imsakum bi ihsan, and divorce is permissible, and it means that divorce should be split over in two periods. Means that the right of divorce is available to the husband, but it is not abundant, it is limited, and it is limited up to two times. If third time it is pronounced in sequence, in third period of the purity, it will render the marriage irrevocably dissolved, and the parties will have no chance to reunite with each other even by contracting the fresh marriage. I hope that soon the decision will come from Supreme Court, and this controversy will also be set to rest at par the triple divorce. Thank you very much.